We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And welcome back to our special Talking Liberty segment on Liberty Nation Radio, where we examine the cases and the stories that impact your rights. As ever, we're joined by Liberty Nation's legal affairs analyst and host of the excellent Uprising podcast, Mr. Scott DeCosenza, Esquire. Welcome back, Scott.
Hi, Mark. Thank you.
So, Scott, the first thing I want to talk about is the Ahmaud Arbery verdict. Now, many people think this was over months ago, but not so, because the three gentlemen in question who have now been found guilty have been found guilty of civil rights violations under a hate crime. So they were back in court for hate crime. Give me your take on this, Scott.
Yeah, the McMichaels, father and son, and Mr. Bryant, who were found guilty of murdering Ahmaud Arbery in state court, have now been found guilty of federal civil rights violations against him. And I thought it was important to talk about, Mark, because it's a thought crime. The charges concern whether or not their killing of their illegal killing of Arbery was motivated by racial bias. That's what the trial was to determine. And they found that it did. And the evidence they used to find that were years and sometimes decades old conversations they had and utterances they made to prove that somehow that they had animus against Mr. Arbery, even though none of those statements were about Mr. Arbery. So if 7 years ago they used a racial epithet in a text message, somehow that becomes then relevant in this trial. And I just thought it was important to bring to people's attention because I think too few people know. And I think it's an outrageous position that the government holds and can get away with, that, you know, speech in one instance is somehow attributable in a negative criminal evidentiary implication to some separate set of facts years later or even decades later.
Well, this is not America is not the only country going with these hate crime trials and hate crime laws at the moment. We've seen plenty of video evidence over the last 18 to 24 months of police officers in Australia and in the United Kingdom going to people's houses, asking to talk about why they sent a message, pointing out that they have not committed a crime, but asking about why they tweeted a certain thing to find out, and I quote here, the thought process.
It is really scary.
What's the legal basis for prosecuting under a hate crime, as it were? Because the three men in question, they've been found guilty. They've been sentenced to prison for a very long time, as they should be for committing an illegal murder. But now they're back in court. Why? What's the purpose of it?
Well, it seems like a piling on. These civil rights violations were initially put in place for this kind of thing. What I mean by this kind of thing is whites killing blacks, murdering blacks in the South, but then having those crimes not be addressed by prosecutors in their jurisdictions because of racism and the legacy of slavery and Jim Crow. So there was good intentions, one would say, to put these laws into place, but then they're used, especially in the current times, I think, when the precursors for their imposition in the first place never occurred, which is to say that the state authorities did prosecute vigorously. So some may say too vigorously, the McMichaels and Mr. Bryant. So what then is the need for an additional federal charge? Well, I don't know, except to say that they wanted a piece of the hides of the villain of the day, or the villains of the day.
I think it's an important question, Scott. It seems important to me, is if, just for example, the three men in question had been found not guilty of the murder, would they then still could have been charged with a hate crime because it's coming from a separate?
Absolutely. We have a dual sovereignty system in the United States, and you can be guilty of criminal behavior for the same actions under federal law that you were acquitted or never charged with under state action. That's what allows that law in the first place. Now, there's a number of people like myself who think that is a preposterous violation of our prohibition against double jeopardy. And one of the sort of things to think about is, well, why wasn't this resolved sort of at the founding or whatever? And it's because we only had 3 federal crimes or 4 federal crimes at the founding of the United States of America. All the regular crimes, like homicide, for instance, were state level crimes. We had piracy, counterfeiting, and treason, I think, were the 3 that the Constitution mentions. So when the federal government has added most of these crimes relatively recently in our history, and we haven't really reckoned with that, I think, in a way that really gives meaning to the protection against double jeopardy when it comes from both state and federal prosecutors.
Okay, on to a more lighter topic, let's call it, Scott. I hear that there's a victory in the American Women's Football Leagues. Tell me more.
We call it soccer here in the States, Mark, and it is, I guess, a victory for them. I just thought it was a real a moment in time about our woke sort of existence now. The U.S. women's soccer team sued for gender discrimination or sex-based discrimination because they weren't paid as much as the men's team were, even though they were fantastically more successful in terms of their being champions. And the problem that sort of most of these stories don't report on is that they were paid literally every single penny they were owed under their contract. When they bargained for their contract and how they would be paid, they had the opportunity to be paid in the same basis that the men's team would be paid on, which is to say, as a sort of percentage of tickets sold or ratings and their position in the field of competitors. But they didn't opt for that, and instead they went with a more secure funding source, which paid them kind of like a regular salary with bonuses involved. And then later on, when their own performance and success revealed that they would have been paid much, much more money had they opted for the less secure version of that, the pay structure. Well, then it was, sour grapes, and they sued. But they're the ones who decided to go under a collective bargaining agreement with that payout structure, which I think it just feeds into the whole notion of, we have this thing where there's this pay gap that people talk about. But of course, as so many economists have laid bare, that gap it's not accounted for by gender discrimination. It's largely accounted for by the choices that women make in the workplace. For instance, to go for more security rather than a higher risk position. But somehow they're going to get paid millions of dollars, even still, Mark.
Well, congratulations to the women's team. I believe their last victory was a result of 3 own goals by the opposition player. And so that was a 3-0 victory for the American women's soccer team. And the last story I want to talk about today, Scott, it's the Gay Wedding Cake Redux 2.0, but this time It's personal and it's about website designs back in the Supreme Court. Give us the skinny on it, please.
Well, I might actually go this time. For people who, I'm sure a lot of people will remember the Masterpiece Cake Shop case. That was the case of a same-sex couple who wanted a baker. It was actually a put-up case, which is to say it didn't sort of occur naturally in the wild. This is a politically motivated case by somebody who wished to crush a Christian baker who didn't want to design cakes to celebrate same-sex weddings. Well, they couldn't abide that. They took him to court, and basically he got fined by the Colorado Civil Rights Commission for not going ahead and giving this couple the cake that they wanted. Well, they went to the Supreme Court. The Supreme Court did not decide on the important free speech right that was implicated, which is to say, can the state compel that speech? The speech being whatever the icing and the text would have been on the cake, right? Instead, they found that there was some procedural issues that allowed them to rule in the case in another way. Well, that was unsatisfactory because, of course, those issues are still out there. And now they're coming back to the Supreme Court in the form of a website designer who wishes to use her talents to design wedding websites. So the popular thing now for a lot of couples is to create a website for their wedding where guest information and such can be posted. And she wishes to engage in this work and has basically sued for a declaratory relief that says, okay, I want to do this thing, but under the current rules, it seems like you're saying I can't do this thing. So what's the deal? Well, she lost in the district court. She lost in the 10th, I think it was the 10th Circuit Court of Appeals. And the case is called 303 Creative v. Alenis. And I think people are going to learn to know that case name, because I think it's going to be a big case. And the current makeup of the court, Mark, I think suggests that this will be a free speech win. That's not a prediction, a firm prediction, but the last time the case went to the Supreme Court, 2 justices supported the free speech rights of the baker to bake his cake, Justice Clarence Thomas and Neil Gorsuch. They're still on the court, obviously, and 2 justices opposed the right of the baker, and one of them was Justice Sotomayor, and the other was Justice Ginsburg, who obviously is no longer with us and replaced by Justice Barrett. So, and we have Kavanaugh on the court instead of Kennedy as well. So I think the court is poised to come out with a free speech favoring decision. I have to say, I hope that they do, because if the state can compel speech based on any number of, priorities they wish to enact, well, then I think it's the death of free speech.
Scott, we'll keep a close eye on this on the pages of Liberty Nation. Thanks for being here.
Thank you, Mark.
And that's almost it for this week on Liberty Nation Radio here on the Radio America Network. I want to thank our guests, Dave Patterson, Andrew Moran, Tim Donner, and Scott D. Cosenza. And of course, you, the listener, thank you for being here. My final thought for this week is President Roosevelt. He once said, "In any moment of decision, the best thing you can do is the right thing. The worst thing you can do is nothing." Now, it seems that world leaders, including Vladimir Putin, are set on a path that will lead them to neither the good thing nor, in reality, anything. As ever, it will be the regular folk that suffer the consequences of decisions that we have no part in. You see, Biden's playbook is an open book. He's been using it for 50 long years. There are no surprises here. But Putin is also playing out his same old tricks, the same he's used time and time again, that the US refuses to look at history and to recognize that we're stuck in the same old game. And if we refuse once again to listen to our history, to recognize it for what it is, to see the patterns, and to understand the playbook that is literally being played out in front of us on a world stage, well, the sad reality is that we're doomed, as ever, to repeat it. There's nothing new under the sun. Thanks for listening. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
We're doing it for real, really real. Liberty Nation.
And Jeff Charles, contributor for LibertyNation.com.
I think we're starting to make an impact. Liberty style, fight for freedom.
Daily tracking poll sponsored by Liberty Nation for Thursday.
Mentioned by Dan Bongino, Rasmussen, Jordan Peterson, and
I
others.
can do it again if you want me to.
Cited in Mark Levin's American Marxism.
I think we're starting to make a really big impact. Get noticed. We're doing it. Rock on. I'm gone.